Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here this morning. We're probably more excited about being here than you are. I said that yesterday and everybody just looked at me like, what do you mean? Before we get started, I want to talk about our procedure for just a moment, and then we'll call the first case. But I know we've got experienced practitioners here today, but I always feel better if we talk about the procedure. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may do so. The proper way to do that is after you've come to the podium and introduced yourself, to request that from the court. Yesterday we had people requesting it from the clerk, and I'm not sure the clerk can grant rebuttal time, but you know, if that's what you feel like you need to do, take your best shot. So anyway, you can reserve up to 5 minutes of rebuttal time. Obviously, appellant gets no rebuttal time. We have a lighting apparatus on the podium. Once you begin your argument, a green light comes on, and the light will remain green until you're about out of time, and a yellow light comes on. Once the yellow light comes on, it means you're running out of time, and when you run out of time, the red light comes on, and we ask that you please respect those time constraints. One of the most important things that I want to make you aware of is all these arguments are being live streamed. I'm told people really enjoy that. I can't imagine watching us have oral arguments, but I'm sure people do that. So anyway, the important thing from your perspective is this. Please think about what you're saying before you say it. We have had some embarrassing situations in the past where some folks have perhaps said some things that they didn't mean to say. And once you've said it, can't take it back. It's out there for everybody to hear. So please think about what you're saying. Your panel this morning will consist of Judge Neil McBrayer from Nashville. The Supreme Court felt that because Judge McBrayer and I were sitting today, we needed some help, so they've sent in Judge Mark Ward as special judge from Memphis. So he perhaps has added to the intelligence quotient here significantly.
There's no question about that.
And we appreciate that. And Judge Ward, we appreciate you being here today. And I'm Steve Stafford from Dyersburg. Miss Angie, anything before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
Louvisia Conley et al. Versus LP Memphis, LLC, DBA Signature Healthcare of Memphis et al.
All right, we will hear from the appellant.
Good morning, Your Honors.
Good morning.
My name is Craig Conley with the Shelby County Bar. I represent the appellants in this matter. I would like to reserve 5 minutes for rebuttal time.
5 minutes. All right,
Yes,
sir.
sir.
You may proceed.
Thank you. This matter involves a motion to compel arbitration that we filed at the trial court level that the trial court denied on the basis that we didn't prove that we presented the arbitration agreement to Mrs. Conley when she was having her mother admitted to my client's nursing home facility. We believe, it's our position, the trial court erred in this regard because the objective evidence shows that Ms. Conley's electronic signature is on the arbitration agreement. The DocuSign certificate of completion shows that Ms. Conley viewed the document, including the documents, including the arbitration agreement, and signed those. And then there's a declaration that was signed contemporaneously by the facility representative that indicates or declares that she presented the arbitration agreement to Ms. Conley. She was given an opportunity to ask questions about it, and that she witnessed Ms. Conley sign that. Also, there's a question that has been raised on appeal that wasn't addressed. Well, there were questions that were raised at the trial court level that the trial court did not address in reaching her opinion in this matter, and that's whether the arbitration agreement is part of a collective agreement pertaining to the admission of Ms. Conley to the nursing home facility, and whether the arbitration agreement is unconscionable. As I indicated, the trial court only reached the first issue, is whether or not the arbitration agreement was presented to Ms. Conley.
And how did that exactly become an issue in this case? And looking at the response, it looks like the response in opposition to the motion to compel arbitration was basically just twofold. Initially, they were arguing that because of the integration clause, that arbitration agreement was no longer valid, but alternatively, even if it was a valid agreement, that it was unconscionable. So how did we migrate from those two issues to this issue about whether or not there was an arbitration agreement presented at all in
Your Honor,
this case?
I believe we migrated there because Ms. Conley testified during her deposition that she was never presented with an arbitration agreement and never signed such. The only document that she thought she signed was a plan of care document. There's been no plan of care document that's been produced or that's in existence in this matter. What she signed, it was a two-part process. The first phase is where the clinical liaison, Ms. Jones at the time, went to the hospital to visit with the resident and the family to make sure that she was amenable, or the facility was capable of handling her needs. And during this first phase, the documents were presented and signed on an iPad. And those documents consisted of the arbitration agreement, the consent and authorizations, the consent for use of image for treatment, and the appointment of a surrogate. Those documents were presented to Ms. Conley on an iPad at, I think the time was 2:08 per the DocuSign certificate of completion. She viewed those documents at 2:08 and then signed those four documents at 2:13 per the certificate of completion. And then, as I indicated earlier, the facility representative contemporaneously executed a declaration indicating that she presented the arbitration agreement to her. She was given Ms. Conley was given an opportunity to ask questions about it, and she witnessed Ms. Conley sign it. So that's sort of how I think we got there, is the position that Ms. Conley's subjective testimony was, I didn't sign anything other than what I thought was a plan of care document, when the objective evidence indicates that she signed these four documents electronically during the first phase.
No one testified live at this hearing. It was based on the depositions?
Sorry, John?
No one testified live at the hearing. It was based on the depositions
Yes, sir.
alone?
Yes,
You
sir.
may want to pull that microphone to you just a little bit, Judge McBride. There you go.
No, there was no live testimony at the hearing before the trial court. It was the deposition testimony of Ms. Conley and the facility representative, Mrs. Jones.
Most DocuSign cases involve the validity of the signature, and Tennessee has adopted the Uniform Electronic Signature Act. But this is a little different twist on the typical case, because as I understand the argument as how it migrated at the hearing was that the signature might be valid, but she never saw the arbitration agreement.
That was her subjective testimony, but the DocuSign certificate of completion indicates that she was presented with these documents at 2:08 to view, and that she executed them at 2:13.
Do we have anything other than the DocuSign receipt to indicate that the arbitration agreement that you're relying on was actually presented here? I mean, is it based just solely on the deposition testimony of your client representative?
No, sir, we have the declaration of the client representative.
As well, okay.
That was signed contemporaneously when she presented the arbitration agreement to Mrs. Conley.
And her signature also appears on the arbitration agreement, does it
Yes,
not?
sir.
Okay.
She was I think Vonda Dow at the time, and now when By the time she was deposed, she was Vonda Jones. So, but I think that's how we sort of migrated to that at the trial court level, was Mrs. Conley's subjective testimony. But
So I'm interested in the integration argument here. It looks like there's an integration and merger clause in that admission agreement.
well, what was signed and what was part of the admissions process, everything was signed on the same day, June the 15th of 2018.
So do we have a complete integration here or just partial integration?
I think everything, all these documents are part of the admission process. They form, it was a two-part process. One, the electronic version, the electronic documents that were presented at the hospital before she came to the facility. And then Ms. Conley came to the facility where she signed a number of other documents as part of the admissions process. She physically wet signatured those. So it would not make sense, Your Honor, that if these documents weren't all part of the admissions process, why would the documents that she signed at the hospital on the same day that the documents that she signed at the facility not be included as part of the complete admission process?
Well, I guess one way you could deal with that, of course, is to specify in the integration clause that this is the entire agreement, including the arbitration agreement that was signed.
Well,
But there's no reference to it.
there's no reference to that, but in the resident handbook, as I indicated, an oral argument contains a reference to arbitration and to the arbitration agreement, along with the other admission documents that Ms. Conley signed electronically and in person, physically.
So where is the arbitration reference found in the handbook?
On page Bates Label 3, it lists documents, and it contains all the documents that she signed by name, including the arbitration agreement. And then on Bates page 38, it contains a section, frequently asked questions about mediation and arbitration, where it lays out an explanation of what mediation is and what arbitration is.
Let me ask you a question about the arbitration agreement itself. Was it a requirement before she was to be admitted?
It was at that time, Your Honor, because that's before CMS came out with the revised rule prohibiting mandatory arbitration agreements. But, so it was required, so she had a choice to either have her mother admitted there or go to another facility that didn't require that if she did not want to enter into an arbitration agreement. Also, it had a 30-day right of revocation that gave her the option to revoke the arbitration agreement within 30 days. And her mother, and it didn't provide that her mother would be evicted from the facility. She could actually stay there. And in that, there was a mandatory arbitration agreement.
You just lost me on that one.
I'm sorry?
If I understood what you've just told me, is it was a requirement for her to sign the arbitration agreement to be admitted. But if she revoked her agreement to arbitrate within that 30-day period, the facility was not going to make her leave.
Correct. There's no provision in the arbitration agreement that upon revocation that she would not be allowed to continue admission at the facility.
I'm not sure how we know that, but anyway, was that the policy?
That's the policy, and that's what was stated. There was nothing in the arbitration agreement that said, if you revoke this, then your loved one or whoever will no longer be allowed to reside here. There's nothing in the agreement that says that. So
is there anything that says to the contrary then, is I suppose my question?
No, there's nothing that says it to the contrary.
All we know is this was required at the time.
Required on admission, but given the right to revoke within 30 days. And that was the same facts as in the, and I'll butcher the name on this case, the Boraski versus Urian case that we cite in our brief, that there was a mandatory arbitration agreement, but it was found to not be unconscionable because it was, like this case, it was a standalone document. It wasn't buried in the other admission papers. It set out the procedure for arbitration. It gave, it indicated bold letters that you're giving up your right to a judge or a jury trial, and it had a revocation clause. And that, in the Boraski case, it was held, like I said, it was a mandatory arbitration agreement that was found not to be unconscionable because of those same factors that I just listed out that are applicable here with this arbitration agreement.
Okay. Think you've used your time.
Thank you.
Thank you. You still got your rebuttal time.
Thank you, Your Honor.
Hear from the appellee.
Good morning.
Morning.
My name is Chad Grady, and I represent the appellee. So, as was said a moment ago, our argument is twofold and fairly straightforward. One, as we argued in the court below, there is no enforceable arbitration agreement that was entered into between the parties because of the admission and financial agreement that was signed after that and the specific wording in that agreement. Number two is, even if you get past that and you conclude that we're wrong about that and that the arbitration agreement was for some reason enforceable, or part of the agreement rather, that it's enforceable because it's unconscionable, both in the way that it was presented to her and in the scheme, the unequal scheme that it sets up if you read the documents all together, as the appellant suggests that you should. And so,
Well, let me ask you a question. Did the trial judge rely upon either of those grounds to invalidate the agreement?
the order that she entered, I believe, simply says that she concludes that there was no evidence that a valid arbitration agreement was presented to Ms. Conley. The order also, however, incorporates the transcript of the argument, and in that, I believe a fair reading of the trial court's ruling in that was that she did take those arguments into account. I think, frankly, more the second than the first, but she talked in great detail about, she said I think there are too many holes in here to enforce this arbitration agreement. There's particularly the issue with the signature next to all five of the reasons that she might have had authority. I won't go through all of them, but she ticks through a few things that led her to believe that essentially this was an unconscionable agreement, and ruled that way. And so her final statement at the hearing was, this court finds that this is not an enforceable agreement as to the arbitration agreement that was signed by a DocuSign prior to the admission and financial agreement. The written order says what it says, and I can't.
So I'm not sure I understand your response to Judge Ward's question. Are you saying then the court basically, by saying they don't find presentment, that was really an unconscionability, acceptance of the unconscionability argument?
Like I was saying, the written order says that the valid arbitration agreement was not presented to Ms. Conley. Was the finding. The finding, the discussion in the trial court hearing tracked more along the unconscionability line, and I believe it's a fair reading to say that that's what her conclusion was at the end. So I hope that answers your question.
Now I'm confused.
Okay.
What I'm reading from the transcript is, and I'm looking at page 44, where the trial court says, so we have the plaintiff saying that this wasn't gone over and your folks not having any independent recollection that is actual evidence showing that this was not opened the amount of time that normally would be to go over this material, along with the fact that she says she's not presented paper copies. Is that pretty much the substance of the ruling of the trial court? Or the reasoning of the trial court, perhaps?
Other than the fact that she, above that, discusses what she found to be quote-unquote holes in the agreement, and her final statement that it is not an enforceable agreement as to the arbitration agreement. Now she may have meant, I may be misinterpreting what she said, she may have decided that she did not find, as a matter of fact, that the arbitration agreement was actually presented. And if she did find that, it would have been based on these facts. It would have been based on the fact that Ms. Conley was handed an iPad.
So the court is saying that the agreement wasn't opened the requisite amount of time for a thorough review of it.
Correct.
But then on the other hand, the court is finding apparently that it was never presented at all. How do you square those two findings?
Well, again, the written order does say what it says, which is that she doesn't find that the arbitration agreement was presented to, I think that's the specific phrase, I think I left it up at my bench, but
But it also incorporates the transcript, correct?
it also incorporates the transcript. And so the way I have interpreted that personally is, on behalf of my client, is that she found that that the way it was presented to Ms. Conley was unconscionable. Now, I will tell you that the undisputed testimony in the case, I know opposing counsel mentioned a declaration that was attached to the arbitration agreement, but the testimony in the case only came from Ms. Conley, who testified that she was never given or told she was signing an arbitration provision, and that when she clicked on the boxes to sign, they had just all signed at once, and it never popped up to an agreement for her to review.
In a case like this, though, we really don't give much deference, do we, to the trial court's findings here, because it was all documentary evidence, correct?
Correct.
Okay, so we're going to look at this on our own and make our, basically, a de novo review, more or less.
I believe that's correct.
Let me go back to something you just said, and I want to make sure that there's a distinction here. As I understand what you're saying the evidence in the record is that the appellant's proof is that nobody has an independent recollection of anything that transpired. And of course, Mr. Conley, I'll give you the opportunity to respond to this in a moment. Is that accurate?
Yes, my reading of the testimony is that nobody from the facility could shine much light in their depositions on what happened, because they could not recall it.
And on the other hand, you've got your client
Correct.
saying, I do have independent recollection of this, and this did not transpire.
Correct.
So we've got two diametrically opposed evidentiary issues there. One is, I always do it this way. Here's my affidavit says I did it, but I don't remember any of it. And your client saying, didn't happen, wouldn't like that.
Right, and I just want to make sure and clarify that I don't think Ms. Conley testified. She is not denying being handed an iPad.
Correct.
She's denying having a significant conversation about these documents and being told what they were. And the testimony that was given by, I believe it was Ms. Jones, is that it typically takes about 20 minutes for her to go through all of these documents. And the undisputed evidence is they were opened at 2:08 and they were signed at 2:13. And not only was the arbitration agreement signed at 2:13, every single one of the signature blocks for all of the electronic documents, and there was more than one, were all signed at 2:13. So the evidence is that the document was opened at 2:08, and everything in it, everything in that iPad packet was signed, 4 minutes later.
How specific was your client about the arbitration agreement? In other words, as far as the evidence that was presented to the trial court, Does your client recall an arbitration agreement, or?
No, I think she testified that she would not have signed one had she known that was what she was presented, and she was fairly adamant that she was told, they were discussing in the hospital room, which is where all this happened, they were discussing her mother's plan of care. And she was told, her testimony is that she was told that's what she was signing. And so she went on to the iPad and checked the box, and all the signatures were attached, and that no document presented itself for her to review. And I believe I believe I'm correct in saying that testimony is unrebutted.
I have not seen her testimony yet.
Let me ask you a factual question. It's my understanding from the record that she had been a resident there for 4 or 5 years?
I believe that.
This nursing home?
That's been a little unclear to me, but I believe there's some testimony.
In and out of the hospital?
Yes, I believe that's correct.
And this time she was going to go back to where she'd been for 4 years and was presented with readmission papers?
Correct.
So did she sign readmission papers to the nursing home every time she went to the hospital and came back?
None of that is in the record, one way or the other. That was just not something that was that was not part of any of the deposition testimony. But I understand your question about it. But Judge McBrayer, you're right that this is essentially a de novo review, and that's, that's why our first argument in our brief was based on the second document she signed, the admission and financial agreement.
And you're saying we can just look at the admissions agreement with the integration clause, make a decision as a matter of law that meant exactly what it said, and that any documents or agreements entered into before that were not valid?
That is correct, because that's exactly what the document says. That document says that everything that comes before it, this represents the entire understanding between the parties and supersedes all previous representations, understandings, or agreements, oral or written, between the parties. This agreement, let me be clear, this written agreement plus whatever in the resident handbook and admission information, and I want to make it very clear, there's no evidence in this record.
So no party argued this, but I asked opposing counsel this question about whether or not this was complete integration or partial integration. If you look at the restatement of contracts, it distinguishes the two concepts. And so you can have an integration clause and it only be a partial integration, referring to only the agreement in question and contemplates that there's other agreements. What would you say to the argument here is that the integration clause in this case is just a partial integration?
So I think, meaning that the things that are integrated together are this agreement and the arbitration agreement.
Yeah, I mean, the way the restatement defines it, it says a completely integrated agreement is an integrated agreement adopted by the parties as a complete and exclusive statement of the terms of an agreement. A partially integrated agreement is an integrated agreement other than completely integrated agreement. So the restatement at least has two levels that you have to look at with an integration clause. And you have to determine, based on the circumstances and the intent of the parties, whether or not a full and complete integration was intended. As I understand the argument, although they don't really say partial integration, is this is really a partially integrated document.
It says, and the document says what it says, this agreement together with the information and documents in the resident handbook and admission information. Now, I'll concede, if they had presented, if they had produced in discovery the resident handbook and information document, or I'm sorry, if they had produced that packet and in it was a printed out copy of the arbitration agreement, I would have a different argument, but the argument I'm trying to make right now would be more difficult. That has not been produced. No one has been able to say what's in the resident handbook and admission information packet, if anything. And my client has testified very explicitly that she was never given a copy of any arbitration agreement. So I think the intent of this agreement was obviously, because it says it, I can't run from it, it says together with the information and documents in this other thing. Problem is we don't know what's in the other thing. And until without knowledge of what is in the resident handbook and admission information packet, I don't think this court can conclude that the arbitration agreement was part of it.
We've spent a lot of time on the integration clause, and I do not want to leave the subject of unconscionability. You make an argument that this is procedurally unconscionable, but I'm not sure I completely understand your position on that. Because in the briefing, it's just very short. It's basically a single paragraph, and I'm not sure I understand. Can you explain to me the upshot of the procedural unconscionability argument?
Certainly. Well, again, we argue, number one, that it was unconscionable because of the way it was presented to her, and we've already gone over that. And I think the case law, you're aware of the case law that that addresses how circumstances like this are considered unconscionable, that someone is given the document, not given a chance to read it, told it's something else, and sign it. And then it's also unconscionable because if you get to the point where you're actually going to try to enforce it, it's completely uneven. Because if you try to meld these documents together, which is what the appellant wants you to do, you're left with a document. One says, we're going to all arbitrate everything. And then the handwritten or the hand-signed admission and financial document says, we can take you to court for this. We can hire an attorney and start a collection action for that. We can sue you for this in court. Those things don't make any sense together.
Well, I mean, is the admission agreement that strong? I thought it just said we can pursue legal remedies. I'm not sure that it says, I mean, and if you have an arbitration, you're going to hire an attorney, presumably, hopefully.
And the appellant made that argument in response to my argument, but in several places in the document, it says, for example, this is volume 3, page 332, signature reserves for itself the right to ask a court to order payment. Signature.
Well, one way to read that consistent with an arbitration agreement is eventually if you get an award in arbitration, you would go to court to confirm it and seek enforcement of the arbitration award. So, I mean, you could read that consistently with arbitration.
I agree with you that there are all the examples that I was about to list, there are ways to read it if you really want to make it consistent with, in a sort of a tortured way, you might end up in court so the two things sort of mesh together. But when you have an agreement on the one hand that says we're going to arbitrate everything that we have between us, we're going to arbitrate. And then over here you have a document that says, picks out specific things and addresses how the patient can be sued or legal action can be taken against them. I think those things are inconsistent.
That's returning to the integration clause argument, but I want to make sure that I completely understand your procedural unconscionability as opposed to substantive unconscionability argument. The procedural argument is what?
That it sets up an uneven, the case law says that that these agreements can be found to be unconscionable when it sets up a situation where one party reserves rights to itself that the other party does not have. And what I'm saying is if you do get to the point where you try to read these things together, that's very difficult to do. When it talks about court intervention, if Conley fails to pay amounts due to as determined by the Department of Children and Family Services, signature reserves the right to seek court intervention. And I understand the facility may ask the court to order you to cooperate fully in the Medicaid eligibility process. Now, you're right. Eventually, I suppose, if there's an arbitration, we would have to mediate that, then arbitrate it, and then someone would have to appeal it. You'd end up in court. That's really the only way that makes any sense. And with all due respect, I think that's a rather tortured reading of the documents. That the only goal is to try to get them to work together, and they just don't in any natural reading of the documents. And that's why we believe the primary argument here is that the thing signed second that says everything else before it is invalidated, and this is our agreement, is the agreement. And because they were not able to identify what was in that resident handbook and then they can't prove that this arbitration agreement was part of it. And second, if you get past that for all the reasons we've discussed, it was unconscionable both substantively and procedurally.
Thank you.
Thank you. I appreciate you letting me go over my time on it.
Hear from the appellant in rebuttal.
Too many papers here, so.
I would expect so.
Well, to address some of Mr. Grady's comments and arguments, the resident handbook was produced in discovery, and it says what I've indicated to your honors today, that it does mention and references the arbitration agreement along with these other documents that she signed. And if we take the
Is
argument...
it part of our record?
Unfortunately, it is not part of the record. I think I discovered this last night when I was going over everything, that it did not make it into the record for some reason or
How
another.
do we know then that the trial court relied or didn't rely on it?
Well, the trial court never got to that point, Your Honor. She just basically reached, as we discussed in the order, as it says, that it was not presented to Mrs. Conley based on too many holes, I think it was her word there. So, but if we take the argument that the only document that exists, despite these other ones, is this one document, the admission and financial agreement. So then we would set aside all these other documents that Ms. Conley signed, either DocuSign electronically or with a wet signature. That she signed all these documents on the same day. So it wouldn't make sense that these documents would no longer exist because of this clause in here that says we rely on the integration clause within that document. It just is nonsensical as to why.
Parties make nonsensical agreements all the time, and because of the freedom to contract, we enforce them.
Yeah. But, Your Honor, these documents address a number of other issues that deal with the admissions process, and that's why our argument is that this is all one set of documents that is part of the admission process that are integrated into one another to complete that process. It just would be nonsensical, and I know we make it all the time, but it'd be nonsensical to have that, these not apply. So also the references to take to court and all that, obviously none of them say we have the right to take Ms. Conley to court. They use terms pursue all legal remedies, which is very broad, and that legal remedy could be arbitration if there is a dispute between the parties. Hire a collection agency or an attorney. That doesn't mean anything about taking anyone to court. Also, the fallback to that is that if Ms. Conley revoked the arbitration agreement, and so the remedy there would be that the facility could seek out court intervention if there was a dispute between the parties. And the same for Ms. Conley. She could also do the same. She could seek out court intervention if there was a dispute between the parties.
Do you know factually, she was a resident for 4 or 5 years there. Each time she went to the hospital, did she have to sign readmission papers?
I do not know that, Your Honor. That has not become an issue as to what the crux of this case is about as far as the motion for arbitration. We're focused on this readmission to the facility on June the 15th of 2018. We did not go back and explore or examine whether or not she had to.
Well, how long was she in the hospital?
I do not know that offhand, Your Honor. Sorry. So
The choice was presented to her, if you want to go home, you got to sign this piece of paper.
if you want to be readmitted to the facility, you have to sign this arbitration agreement, or you have the option to seek out alternative places to reside. And then, I mean, she did have the right within 30 days to revoke this, and there's nothing in any agreement that says that, but if you do revoke this, you will have to seek admission at a different facility, an alternate facility.
I got a problem with that one.
So she goes in and out of the hospital. Each time she comes back, she has to sign something?
think it's each time. I think there's a clause, if I remember correctly, that you don't have to sign all the submission documents every time. And I don't know why they were having to be readmitted. I don't know why. I don't know the factual background as to why they were presented to her on this occasion.
This particular agreement that says if you're readmitted later, this arbitration clause will be applicable.
Yes, sir.
But her prior agreements that she entered into, we don't know what they said.
We do not know what they said. We've not
I
explored
mean,
that.
I'm assuming that's a consequence that they can only reserve a bed for a certain amount of time when you go to the hospital.
It probably is the bed hold policy that's in play here with Medicare, Medicaid, and the financial providers. So, but with that, Your Honor, Your Honors, we believe that the trial court erred in denying the motion to compel arbitration, and we request that you grant that motion, reverse it, and send this case to arbitration where it should be, where the parties agreed it should rest. So, thank you.
Thank you. Thank you, counsel. We appreciate your briefing, appreciate your arguments, and we will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be excused. Thank you. We are going to take a brief recess for